Hi, everybody. Today's video is to answer a really common question that I get, which is what happens if I die without a will? And to start off with, I'm first going to define some terminology. And the big one that you're going to hear is intestate. So intestate or intestacy, if you ever hear those terms used, it simply is referring to an estate where somebody died and they didn't have a will. That being said, what is the answer to the question? If I die without a will, if I die intestate, what happens to my assets? The good news is, and to dispel a very common myth, your assets, at least in Connecticut, don't go to the state. So you don't have to worry about all your things going up to the governor's mansion in Hartford. That doesn't happen. What does happen is that your assets pass in accordance with what's known as the laws of intestacy. So Connecticut has a state law that says if you die intestate, it writes kind of the default rules for where your assets are supposed to go. And how those default rules work essentially says that your assets are going to go to your closest living relatives, your next of kin, which sounds like, a pretty good result. But in practice, it may result in some unintended assets passing to some unintended beneficiaries or passing to certain beneficiaries in unintended ways or unexpected ways. So it's very important to understand what these laws of intestacy are and how they work. So what are the laws of intestacy specifically? So this chart is going to show you, so the left-hand column shows who your closest living relatives are, and then the column on the right shows, so based off of your closest living relatives, who are going to be the actual heirs of your estate, the beneficiaries receiving the assets. So if your closest living relatives are that you have children, so you don't have a spouse, but you have living children, then it's simple. 100% of your assets go to your children. If you have a spouse and no children and no parents, then your assets go 100% to your spouse. So far, so good. Here's where it starts getting a little bit more complicated. If you're survived by your spouse and your children, and those children are the biological children of both you and your spouse gets the first 100,000, but then the balance is going to be split between the spouse. So your spouse gets 50% and your kids get the other 50%. So this sounds, again, pretty good, but think of it practically speaking. Let's say you solely owned your house. So when you pass away, the first $100,000 of the house and the bank accounts or any other assets that you have go to your spouse, but then the balance is going to be split between your spouse and your kids. So if your spouse is in your 40s or 50s and the kids are still little, for example, that may mean your spouse may end up owning the house jointly with your minor children or younger children. So again, on paper, it sounds good to say your assets are passing to your spouse and your kids, but in practice, it may not work out as well as you think. The next scenario here is where you have you're survived by your spouse and a child, but that's not the same child as your spouse. So you're the biological parent, but your spouse is not. That means your spouse gets half and the child gets half. So again, on paper, maybe sounds good, but in practice, maybe doesn't work out so well, as I kind of explained in the hypothetical for the prior example. If you do not have a spouse and you do have a spouse and no children and you're survived by your parents, now your spouse is splitting the inheritance with your parents. So in that case, the spouse gets the first 100,000 and 3/4 of the balance, with the balance passing to your parents. So we're starting to maybe get away from it working out as you intend if you're just simply relying on these laws of intestacy. Another case, so in this case, you have no spouse, no children, but you have parents. So instead of so far, we've pretty much been going down the family tree. So starting with spouse, but then going down to kids and lineal descendants. But if there's no place to go down, then the laws of intestacy go up. So we go up to your parents. And if you have surviving parents or a surviving parent, then they get 100% of the assets. If you do not have any surviving parents or a spouse or children, but you have siblings, then the assets go to the siblings. And from here, even we get further afield. So let's say you have no siblings, but you have nieces and nephews, then assets go to your nieces and nephews. If you don't have siblings or nieces and nephews, we're going to go back up your family tree again and go to your grandparents. And if your grandparents have predeceased, then we go to aunts and uncles. If they've predeceased, we go to cousins. So the way these rules work, again, is we're just kind of filter through your family tree to find the closest living relatives that we can. And those are going to be the folks that are the beneficiaries of your estate. So I would think long and hard about whether those laws of intestacy are going to work for you. And if the simple answer is no, then I would always recommend having a will in place, because these are just the default rules. You can always override the default rules with a will specifically stating what your wishes are. So that's the answer to the question of what happens if you die without a will. If you have any other questions, please contact me. And you can find my contact information on our website, kkc-law.com. And I look forward to having you guys tune in to further videos.